We're so happy to have all of y'all on this call. What we're going to be doing today is for about 90 minutes, and of course, y'all can leave when you need to. But we're going to be digging into this particular political moment of Masterpiece Cake Shop, the current oral arguments that are happening right now at the Supreme Court, and using this moment of religious exemptions to untangle the logic of Christian supremacy here, to break down the trending right-wing legal strategy and just explore together how it weaves together the justice issues that are faced by LGBTQI people, people of color, and women particularly. I'm your resident tech person for today and will help facilitate the call. And so I wanted to give you all a couple of pieces around that. We are recording the webinar, and so if you have to leave early, then please go on and do it, and we will be really excited to send you the notes in this recording afterwards. Just give us a couple of days to get it online. Please feel free to use the chat bar. We love the conversation. There will be a couple of moments for y'all to chime in with your own responses to questions or your own questions yourself. If you have any questions or you need any help, feel free to privately message me on Zoom or to email me at the same email that I got in contact with y'all for the registration. If you are on Twitter, we're going to be trying to live tweet and facilitate this space. And if you want to use a hashtag to follow along with the conversation or invite folks in, our hashtag is going to be ain't about the cake, and I'll type it into the chat bar when I'm done. Before we move into framing out the space with a conversation of what exactly is Christian supremacy, I invite y'all to just go ahead and introduce yourself in the chat bar. So go ahead and write your name and where it is that you're coming from. So on you, Alva, go ahead.
Thank you, love. So we're going to be going deep into specifics and wide. And so I'm just going to take 90 seconds for us to think through what is happening right now. So the definition of Christian supremacy that Soulforce uses is the idea that using the language, the culture, the sacred text, the dogma of Christianity for the purposes of discrimination, harassment, oppression, domination in general, is what we call Christian supremacy. We are really clear that that is not a religion, that is actually a tool of oppression. And so what we really work hard to do is disentangle the politics, the rhetoric, the idea of what is going on power-wise from the religious practice. And so we hope that for those people on the call who identify as Christian or people of faith, that you understand that we are specifically talking about a corruption or a stealing of a religious language culture for the benefit of domination and white supremacy and capitalism and things like that. So that's really important for us to name. And we wanted to just throw up a little graphic, if Joss can do that, that gives you an idea of kind of why this is tough, right? This is a popular meme on from the opposition. And it says, for folks who are on the call, it says, religious freedom isn't free. Many gave their lives so you could know Jesus. And that concept of being able to frame the conversation around this is about my personal and private rights to my religion without taking into account the impact on others, in fact, many others, is exactly what we mean by why religious exemptions are not based in a religious thought, this idea that was supposed to be used to help protect particularly religious minorities in a Christian supremacist, white supremacist country. This is the frame that is happening on the other side. And so it's really important for us to really grapple with why it's hard to have these conversations sometimes in our churches with our neighbors at dinner, if that's the thing. But it's really important for us to know the facts also as part of how we talk about that. So throughout the call, we'll be talking about details and facts. We'll also be talking about the ethics in the larger picture and how we respond to that. So we would love to just pass it on to Columbia. Actually, Joss, I think you were going to do that, inviting people to use the chat bar, and then pass it on to our amazing comrades to further the conversation.
you want us to just pick it up, or do you want to do a real handoff?
I do want to invite folks to use the chat bar to just, if you are we are all coming to this call with something that interests us about this conversation of religious exemptions. And so please do add your own either experiences around religious exemptions, whether it's conversations or where the idea of religious freedom has been used to harm you or someone you love personally. Or something in the conversation that you're just struggling with. Just bring your stuff to the conversation, what it is that you're thinking about around religious exemptions in this particular political moment.
Yeah, because we'll eventually get to a Q&A, and so it's really helpful to generate that content while we're in the call and for people to stay active in the chat bar.
Yes, and also before I could get back to you, Catherine, can I ask y'all who are participating to please keep yourselves on mute so that our facilitators can have quiet space to talk. Thank you. Go ahead, Catherine.
Well, thank you so much. Again, for those of you who've just joined the call, I'm Catherine Franke. I'm a professor at Columbia Law School, and I'm the faculty director of a project we run at Columbia on religious liberty and how to balance religious liberty rights against or in harmony with LGBT rights, reproductive rights, racial justice, etc. The project is called the Public Rights Private Conscience Project, and Kira Shepard, who's here with us today too, will be talking a little bit about the particular work that we're doing around racial justice. But if I can convene you all in a sense of being in law school for a minute, the unique U.S. commitment to religious liberty is something that was formulated early on in the founding of the United States, because so many of the people who were settlers from Europe, white settlers from Europe in North America, were fleeing religious persecution in Europe. So they saw themselves as religious dissenters, and they were coming to the United States as members of religious minority groups to find freedom, both political freedom but also religious freedom in the U.S. And so it's important to keep that background in mind as we think about both the separation of church and state, which is a fundamental American idea, but also the way that from the very beginning, religious liberty and equality have been intertwining and mutually reinforcing ideas. So one of the Supreme Court's first religious liberty cases was at the end of the 19th century involving Mormon people who were basically rendered criminal because of their some of their religious practices, most specifically polygamy, by having more than one wife from male members of the religion. They lost in bringing a First Amendment challenge, a religious liberty challenge to the Supreme Court, in part because the Supreme Court and the society in general raced them. They were read as people of color, even though today we would understand most Mormons as being white. So race in the 19th century actually wasn't about skin color. It was about something else. Irish people were considered black. Italian people were considered black. And Irish and Italian people were also discriminated against because they were Catholics. And so racial equality and religious minority group rights have always been intertwined with one another. And it wasn't until the 1970s when we saw the beginnings of a civil rights movement really taking form in the U.S. and many federal laws passed, Civil Rights Act protections passed by the Congress, that we also start to see the Supreme Court respecting religious liberty made, again, by religious minority groups, Amish, Seventh-day Adventists, Mennonites, Jews, and folks like that who were living in the United States and who were being discriminated against because, for instance, their Sabbath was on Saturday, but they were being asked to work on Saturday, or their devotional practices in some way violated workplace rules or rules that might qualify them for unemployment benefits. And as the Supreme Court said, yes, you have a religious liberty right to practice your religion and not be negatively affected by those practices, the court said we're going to draw from the same kinds of cases that we've developed to protect racial minorities, to protect religious minorities. And so the court explicitly saw these two, religious discrimination and race-based discrimination, as mutually reinforcing principles. And I think that's what's at stake today in the Masterpiece Cake Shop argument that was in the Supreme Court this morning, which I have to say, I just read the transcript of the argument. most people who aren't lawyers find transcripts of legal arguments boring. This one's just hysterical. Justice Ginsburg, Justice Kagan, Justice Sotomayor put the lawyer who's defending this baker who wants to refuse service to a same-sex couple who wanted a wedding cake. They just put her in the hot seat, and they say, well, what about the engraver for the invitations? What about the caterer? What about the tailor that's, making the beautiful dresses or tuxedos? What about the makeup artist, the hair artist? Are they also engaging in expressive activity that deserves First Amendment protection? And the woman, Kristen Wagner, who I've debated in other contexts, is kind of squirming as she stands there. But so it's a total hoot to read. And I encourage you, if you want to get a laugh out of the Supreme Court, which doesn't happen that often these days, to take a look at the transcript, which is available on the Supreme Court's website. Justice Kagan says, well, they do describe themselves as makeup artists, after all. So shouldn't we treat them as artists? If your cake baker then says that he's an artist also. So one of the ways that this case is being framed, the Masterpiece Cake Shop is being framed, is that people are using religion as a license to discriminate against gay people, against trans people. I would say, and Kira will say more about it in a moment, against women of color and their reproductive rights and reproductive justice issues more generally. And I think the long game here is also to unravel racial justice protections in a whole range of contexts, which we'll get to a little bit later. I'm a little troubled by that framing, the license to discriminate framing. The groups that are working in this area, our partners, have tested that expression through polls and other sort of focus groups, and it tests well. But what it does is it sets up a antagonistic relationship between religious values and secular values, between faith and equality. And of course, there are many people of faith who are progressive. There are many people of faith who believe in gay rights, reproductive rights, racial equality, right? And what we've seen in the last 10 years or so is the capture of the idea of religion by religious conservative Protestants, by evangelical Protestants, and all other people of faith bear the burden of being labeled as bigots because these particular folks who are really running the idea of what religious liberty means have set them up as bigots because we don't have any broader idea of what it means to be a person of faith. So I think by saying this is a license to discriminate makes it difficult for people of faith to come forward and say, actually, I am a member of a faith-based community. I am a member, I believe in God. I believe in some higher power. And I also think that these laws prohibiting discrimination ought to be enforced. So I'd like to move away from the license to discriminate frame. And instead, as we argued in a brief in the Masterpiece Cake Shop case, and we also published in an article in Slate yesterday, is that the argument that the cake baker is making is actually bad for religion itself. Right? Because religious minorities, as I said earlier, have always depended on anti-discrimination principles in order to freely practice their faith. And it's because their religious practices are different from the majority, from a Protestant, some now more evangelical majority, that they depend on non-discrimination laws to make it possible for them to work. So for instance, Abercrombie and Fitch can't tell a young woman she has to remove her hijab, her headscarf, in order to work there because she doesn't look like the kind of employee they want there, right? She needs both religious liberty and equality in order to function in the wage labor market, or other examples we can think of people at schools or entering businesses. They suffer all sorts of discrimination because of how they look or how their religious practices dictate their lives. And so I think it's important in this case to point out that religious liberty is at risk with the arguments that this kind of narrow sect of people are making in cases like the Masterpiece Cake Shop case here. It's worth, I also think, noting that it's not a mistake that they picked these facts, this kind of story, to take to the Supreme Court to raise this issue. As the hashtag says, it's not about the cake. Well, that's sort of their strategy as well, is, oh, come on, it's just a cake. It's not that important. Go get a cake somewhere else with somebody who likes you. Even David Brooks did an op-ed in the Times today saying, what are the gay people getting so upset about a wedding cake? Go somewhere else and get a cake. Don't you want to have a cake made for you by somebody who likes you? Well, we could say the same thing about people of color being turned away from restaurants or hotels or businesses of various sorts. Go to a different lunch counter. Take a different bus. Really, what's the difference? And what's the difference here is that what's at stake is an underlying principle of equality, that if you open up a business to the public, you can't pick and choose which people you want to serve based on either your bigotry or your religious beliefs, because you are a business regulated by the public and made possible by licensing and other forms of public enablement, really, to have that business. So it's a smart thing for them to have brought this case because the stakes seem kind of low in a wedding cake, really. But actually, the principle is enormous. And the second thing about why this was an important case for them to bring is that the longer term game, and make no mistake about it, the longer term game for these folks is to unravel race discrimination protections and public accommodations. We have reached pretty much of a consensus around housing discrimination, workplace or employment discrimination. You can't discriminate on the basis of race or sex or national origin or religion in those contexts, but public accommodations, these are businesses. The right wing never really conceded that non-discrimination principles should apply in businesses. And the idea is, it's my business. I should be able to decide who to serve, how to serve it, and the government shouldn't be able to tell me that I can not reserve or refuse service to certain people. It's a kind of libertarian individual rights idea that the right has never gotten over from the bad old days of Jim Crow. And so they're using these gay cases where the stakes seem low, like with a wedding cake, to unravel what is the larger principle of businesses being able to refuse service to Black people, to interracial couples, to a wide range of folks that they don't want to serve. So know that this is a much larger agenda. These people are smart. They have smart lawyers. They're making very smart arguments, and they're using very good cases in order to, like the Little Sisters of the Poor in the reproductive rights context, why would you want to make a bunch of nuns use contraception? Well, that's not really what that case is about. Although when they haul out the nuns, it makes you think, well, really, why should nuns have to use contraception? So they're careful about what cases they choose so that the equities, the sort of what's at stake, bends in their direction. But there's a much larger agenda here. And it's one of really subsidized by the Koch brothers, not by people of faith in many cases, who want to get government regulation out of businesses and let businesses decide how to regulate themselves. So let me pass it off. Let me say one other thing about the law, which I think you want me to do, which is to talk about the Religious Freedom Restoration Act, which is a federal a federal law that was passed in 1993 that basically by statute, by law, restated what had been the First Amendment, the constitutional standard of religious liberty prior to the 1990s. And what the statute says is that no federal policy or law can impose a substantial burden on a person's sincerely held religious beliefs. So any kind of policy that would force you to violate your religious beliefs is unenforceable as to you. And oddly enough, or interestingly enough, in 1993, the left and the right came together in support of this federal statute, largely because the left wing had religious minority groups in mind. And they felt that this was an important non-discrimination principle, really, for religious minorities. But the statute has actually ended up being used mostly by the right wing to avoid, Kira, you're right there, to avoid compliance with laws that they don't like Roe versus Wade, like the contraceptive mandate that's in the Affordable Care Act, et cetera. And so RFRA, as we call it, the Religious Freedom Restoration Act, is this federal law that grants broad religious liberty rights, and I think many of us agree, has been interpreted very broadly by the Supreme Court in a way that, for instance, allows a company like Hobby Lobby to have its own capacity to bring religious liberty claims, when most of us think that religion is something that we as people might want to protect, not something that a company can have. Companies don't go to church on Sunday, right? Companies don't go to Passover. companies don't go to services on Friday nights. People do that, but the Supreme Court has said that companies are people too, corporations are people too. It turns out in many respects they have more rights than humans do. So that's the longer term kind of work we all have to do, is to see how these laws that were supposed to benefit minority groups are actually being used to benefit corporate interests in the name of freedom and equality. So let me pass it off to Kira, who's going to talk a little bit more about our racial justice work and what the stakes are for racial justice in the Masterpiece Cake Shop case, but in the religious liberty cases more broadly. And then lastly, just say that one of the terms that we're using, that Kira has really advanced in her own work, is not just the problem of Christian supremacy, but white Christian supremacy in cases such as the Masterpiece Cake Shop and others. So thanks. Kira, go ahead.
Yeah, thanks, Catherine. Thanks for that. It was really helpful. And yeah, white Christian supremacy is a term we're advancing as part of the work that the Public Rights Private Conscious Project does. The reproductive justice, LGBTQ. I'm really here to talk to you all about the way that, am I going in and out?
Yeah, you are. You want to come in Kira's down the hall from me. She could come in my office and I'll yak for a second while she picks up her computer and comes over here, if that's okay.
That's great.
I think one of the things that she will be talking about in a second, I don't want to speak for her, of course, is, here she is. All right. Okay. No,
I can take this out. I'm gonna take this out. Okay. Hi. Okay, hi. Sorry about that. I had some problems with my own computer. So yes, I'm going to be talking about how religious liberty laws impact people of color. I'm the Racial Justice Director at the Public Rights Private Conscious Project, and that's what we focus on. When I talk about religious liberty laws, I like to talk about the ways that religious objectors has used religious liberties to discriminate against marginalized groups dating all the way back to like the 1950s. And the first group that they used religious exemption laws, liberty laws to try to discriminate against or justify discrimination against were actually Black people. So back in 1954, after the Supreme Court decided the Brown v. Board of Education decision, when they said that public schools can no longer segregate, and that was unconstitutional, a number of white Christian families started something called segregation academies. And the way they were able to do this is because Brown v. Board applied to public schools, but segregation academies were private schools. So they were able to discriminate and have these racially discriminatory policies and still received federal tax benefits. But then, and all of this was part of this theology called Theology of Segregation at the time. So after Brown, a number of white Christian groups, even churches, wanted to rely on the Bible to push forward this narrative about segregation, using Bible verses to say that segregation was good and that the races shouldn't mix. They were against miscegenation. So back to these segregation academies. So they were allowed to segregate because they were private schools, but then in the 1970s, in 1970 exactly, the IRS changed their policies and said that private schools that had racially discriminatory policies could no longer receive tax-exempt status. So at that point, some of these segregation academies had to open their doors, but some of them didn't. And one was Bob Jones University that had a policy that didn't allow Black applicants until 1971. And then they continued a racially discriminatory policy where they didn't allow interracial dating. They sued the IRS regarding the fact that they couldn't get tax-exempt status because of their policies, and the case went all the way up to the Supreme Court. Luckily, in 1983, the Supreme Court said that the government had every right to withhold tax-exempt status from Bob Jones University, even though they could continue with their racially discriminatory policies for a number of years afterwards. So that's one example of how religious objectors try to use these laws to discriminate against people of color. And thank God the Supreme Court stopped that. But then you had another case called Newman versus Piggie Park. So in the 60s, there was this barbecue chain called Piggie Park, and it was owned by this guy named Maurice Bessinger, who was the Baptist head of the National Association of the Preservation of White People. So this guy, Maurice Bessinger, he had this barbecue chain, and he didn't allow Blacks to frequent the chain. They couldn't come inside the restaurant. So then one day they turned away the wrong person. She was the wife of a Black pastor. And then from there, they were sued by an African-American attorney who brought a class action case against Maurice Bessinger. And he said, and the case went all the way to the Supreme Court, and he said that the Civil Rights Act violated his religious beliefs because according to his freedom of religion, because according to his religion, it compelled him to oppose any integration of the races whatsoever. Thankfully, the court dismissed the case and called it patently frivolous. But once again, we see religious objectors trying to use their religion and the Bible to discriminate against people, and this time it was Black people. So the next group they tried to use religion to discriminate against, this time they had more success, was right after Roe v. Wade. And what we see with these cases, so first we have the Brown versus Board, then we have Roe in the 70s, then recently we had a Obergefell. So we see the strategy being used by religious objectors where marginalized groups such as Blacks or women or other people from LGBTQ community receives rights. And then these religious objectors try to use religious liberty laws to kind of hollow out these rights, make these rights meaningless. So with Roe, as many of you know, that gave women access to reproductive health care rights in 1973. After that, there were a number of amendments called conscience clauses. One such conscience clause was the Church Amendment. The Church Amendment came out in 1973 as part of a law that Nixon passed. And it basically said that all medical healthcare providers and institutions that receive federal funds could not provide abortion services or sterilization services to people based on their religious beliefs. From there was another amendment called the Weldon Amendment that said that any group that discriminated against anyone that didn't provide, and no groups that receive federal funds were allowed to discriminate against medical institutions and healthcare providers that didn't provide anyone reproductive healthcare services because of their religious beliefs. So this time we see religious exemption laws being used successfully against a marginalized group of women. And then recently in 2015, we had the Obergefell versus Hodges decision. And this is the decision that legalized same-sex marriage, as most of you know. And then since that decision, we've seen a backlash of religious exemption laws being proposed on the federal and state level. In many ways, the Obergefell decision itself kind of teed up the current religious exemption backlash that we're seeing against LGBTQ, anti-LGBTQ discrimination laws. Because in the decision itself, it says that those who deem same-sex marriage to be wrong reach that conclusion based on decent and honorable religious or philosophical premises, and neither they nor their beliefs are disparaged here. So looking at that background, we see that the religious right won as far as reproductive health care refusals for the most part. When they tried to do it against Blacks, race, they didn't win. But as Catherine was saying, with this recent Masterpiece Cake Shop case, it seems like weakening public accommodation laws is the first step to allow discrimination against Black people could be the first step in places of public accommodation. And then as far as LGBTQ discrimination, I think the jury's still out as far as if a lot of these religious exemption laws that we're seeing being used to push back against rights for LGBTQ people are going to be allowed to move forth, and if they would be passed. But I think under the Trump administration, when we see more people who have white Christian supremacist beliefs actually in the administration, there's a good chance that we're going to be seeing more and more of these laws being passed. Now, earlier I talked about how religious objectors try to use religious exemption laws, religious liberty laws to directly discriminate against Black folks. And now today we don't see that. But when you look at some of these laws, you see how they can actually harm people of color more so than any other group. So one such law is the First Amendment Defense Act. The First Amendment Defense Act was introduced in 2015. In 2017, Republicans were talking about introducing it again. That never happened. But Trump did say when he was on the campaign trail that if it came across his desk, he vowed to sign it. The First Amendment Defense Act says that a religious objector could discriminate against someone who's in a same-sex marriage. And when this law was first discussed in the media, all the talk was about just, the fact that this law will allow discrimination against people in same-sex marriage, people in the LGBTQ community. But a lot of people didn't touch upon the provision where it says, and also people have sex outside of marriage. So, a good majority of us have sex outside of marriage, but the easiest way to recognize when someone has sex outside of marriage is if they have, if they're pregnant and unwed, and so they're pregnant outside of marriage, out of wedlock. So that's why this law would impact a large number of women, but particularly women of color, particularly Black and Latino women who have higher rates of pregnancy out of wedlock. And this is particularly troublesome because Black and Latino women already face high rates of pregnancy discrimination. So this would just compound and harm the discrimination that they already face in the workplace. The way the law works is that it prevents the government from penalizing or fining a religious objector for if they discriminate against someone because they're in a same-sex marriage or because they had sex outside of marriage. So, for instance, if a landlord decides not to rent an apartment to an unwed mother, they could do so without fear of being penalized under the Fair Housing Act. Or if an employer decides that they wanted to deny an unwed mother maternity leave in violation of the Family Medical Leave Act, they could do so without fear of being penalized by the Department of Labor. So these are scary times, and these are laws that can very well easily be passed any day now. Another thing that our particular group is looking at as far as religious exemptions that impact women of color under the reproductive health care refusal is religious exemptions are the Catholic hospital ethical and religious directives. So the Catholic hospitals, the United States Conference of Catholic Bishops created these guidelines for Catholic healthcare providers called the Ethical and Religious Directives that basically say that healthcare providers, Catholic healthcare providers, do not have to perform, well, they can't actually, do not have to, they can't perform abortions, intravitreal fertilizations, sterilizations such as tubal ligations, and they can't give out birth control pills. Now that sounds bad, but I like to give this story to really illustrate how these type of directives harm women. And it's a story about this woman named Tamisha Means. So in 2010, a woman in Michigan, she was in her 30s, her name was Tamisha Means. She was 18 weeks pregnant, African-American woman, and she went to the closest hospital to her, which happened to be a Catholic hospital. She was in a lot of pain, and the Catholic hospital, and she didn't know it was a Catholic hospital and that they operated under these directives. The Catholic hospital at the time, they examined her and saw that her fetus was no longer viable. But they didn't tell her this, and they didn't tell her that she was at risk of infection, and that the most medically sound way of taking care of her particular condition was to abort the fetus. Instead, they just sent her home with aspirin. And this particular complication that she had, if it continued, it was really life-threatening. It could have caused a complication called sepsis, which is life-threatening. So they sent her home twice. She came back again in a lot of pain. They sent her home twice. It wasn't until the third time, when she began to miscarry, that they had to operate on her. And at this time, she was miscarrying, so they operated on her. It wasn't until months later that she realized that everything that she went through was because she went to a Catholic hospital. She tried to sue the Catholic hospital with the help of the ACLU. She sued the United States Conference of Catholic Bishops. She brought a negligence claim against them, saying that she was under tremendous emotional distress and that she was in a lot of pain. And she lost at the district and appellate level. They basically said she didn't have a physical injury. So there's really no, at this point, it doesn't seem like a woman who undergoes such traumatic treatment at a Catholic hospital has any type of recourse within the law. So what we're doing right now, we have a study where we're looking at Catholic hospitals and how the Catholic hospitals' ethical religious directives impact women of color. We teamed up with a social science group, and they did a test that looked at Catholic hospitals across the nation. And the long and short of it is that they found that in a substantial number of states, Catholic hospitals' ethical and religious directives likely disproportionately impact a large number of women, disproportionately impact women of color. Now, this is important findings, and I find it to be particularly important because of the racial biases and racial disparities and health disparities that women of color already face. So, for example, women of color, Black and Latina women, have higher rates of unattended pregnancies, 3 and 4 times higher than white women, respectively. So when you talk about tubal ligations, and Catholic hospitals don't allow they don't allow for the women to have their tubes tied. This impacts women of color, or all women who actually rely on tubal ligation. They get the tube tied so they don't have an unattended pregnancy. So you hear stories about women who actually go to Catholic hospitals while they're pregnant and right before they deliver their baby, when they're on a delivery table, they say they tell the hospital they want to have their tube ties after the surgery, and they don't find out until that whole process that they can't have their tube ties after the surgery. And actually, it's actually cheaper, and the safest way to have your tube ties is like right after the pregnancy. But the Catholic hospitals, they just won't do it. So the woman will either have to come back and it costs more money, or a lot of times they just don't have their tubes tied. And then I've heard stories of advocates against Catholic hospitals tell me that they worked in hospitals where they've seen a lot of women of color come in who actually, right after they have the child, they see them months later come back in pregnant. And a recent report actually showed that since the growth of Catholic hospitals, tubal ligations has gone down 30%. So this is one way that the directives particularly impact women of color. Another way is the fact that women of color have higher uninsurance rates. So a lot of women of color don't have health care. So if you don't have health care, you don't get prenatal care, and then you're more likely to have the type of complications that Tamisha Means had that I just described, and which means that there might be a greater need of you to have an emergency abortion, to have the fetus aborted. But that can't happen if you're in a Catholic hospital. In our report, we highlight the story of this woman, Laurie Bertram Roberts, who was a low-wage worker, uninsured, and 18 weeks pregnant, just like Tamisha Means, when she went to the Catholic hospital. Once again, she was young, didn't know they operated under these ethical religious directives. And they sent, and they same thing with Tamisha Means. They saw the fetus wasn't viable. They didn't tell her that. They just sent her home twice. She didn't know what was happening to her. She was in excruciating pain. She went there twice. The third time she felt this pain, she wanted to go back, but because she was uninsured and a low-wage worker, she was like, my bill's already backing up. I don't want to go back to the hospital the third time. She never went back. She bled profusely in her home. They had to call an ambulance and bring her to the hospital. At this time, there wasn't a heartbeat, a fetal heartbeat, so they operated on her. So these are some of the ways that religious exemptions particularly impact people of color. And I went over like the history of when they first started. Like the religious objectors definitely wanted, the intent for a lot of religious objectors was to use religious liberty laws in a way that would allow for discrimination against Black people. So this is why this is a good time to be talking about ways that the Masterpiece Cake Shop case could potentially harm people of color around public accommodation laws. And it's a good time for us to be having this discussion.
Thank you, Kira. Yeah, that's a lot of information. Thank y'all so much. It's incredibly helpful to have the specifics and the nuances of the legal side. At Soulforce, we do a lot of work around right Christian supremacy and how that relates to LGBT people, people of color, and women. And we're coming at it in general from a macro point of view. One other piece of something I wanted to mention to just have as part of the conversation, and Kira and Catherine, I'd love for you to jump in as needed or wanted, is that the Title IX exemptions that we have been working on Christian college campuses for almost 20 years now. And our most recent waves of Title IX exemptions, which were recently put into place to be able to discriminate against women, are now in place to be able to discriminate against queer and particularly trans people, particularly in areas of accommodation. And so have done a campaign called Give Back 9, where we've been really encouraging our folks to kind of rise up against those federal exemptions for those college campuses. And we've been doing several actions last year and also pushing on the NCAA to figure out how we can leverage other pieces of the pie, both economically as well as alumni, students, faculty, and staff. So it's really important to see how all of this stuff connects, because when we talk about intersectional organizing and intersectional justice, we have to understand that at this moment it may be about a cake shop for LGBT equality kind of rights conversation, but we can never ever lose sight of what both Kira and Catherine so beautifully shared around, like, this is actually also about white supremacy. This is also actually about like individual property rights. This is actually going all the way back to the oppressive foundations of this nation and that stuff. So what the other pieces that Soulforce would like to add to this conversation is around the ethics of the conversation, because a lot of us can learn the facts, but then we still struggle on like how to have these conversations in our own homes or churches or families, especially with the holidays coming up. I've been hearing lots in recent days about folks who are just like, I have to go home and I love my family. And also like, how do I have conversations about these things I feel really are important to our family or to me or to our religious beliefs, but don't quite have the language. How do you talk back to that kind of language around like, this is my religious freedom? So part of what we really encourage folks to do is not use that language. Like, this isn't about religious freedom. This is about religious exemptions. Because part of it is like the dog whistle of Christian supremacy is like, oh yeah, one of the foundational principles of this country is religious liberty. And so if you're talking about religious freedom, then already in our minds as cultured people, like cultured Americans in a Christian supremacist society is we want to say, yeah, we do believe in like the freedom of religion. So we want to be careful on how we even use our own language and how we talk about it. That helps us really try to decode that Christian, particularly white Christian supremacist narrative, and make it, lay it bare for what it actually is. And so for us, we think when we're talking to folks, to help them think through how to have these conversations interpersonally or within institutions, we talk a lot about the ethics of religion, that religious systems are kind of organizing principles around living a moral and ethical life. And when we talk about this concept of religious exemptions, it is prioritizing one's ability to practice one's individual faith to the detriment and harm of many others and multiple communities. And so for us, we live into the idea, our measuring stick in general around the Bible, theology, dogma, practice is the concept that if it is creating life and life abundant, it is a good theology. If it causes death and harm, it is not a good theology, no matter where it's written, no matter what it says, that we have to take responsibility for our own religious beliefs. And so how our religious beliefs impact other communities and people is absolutely critical to the conversation around when we're having conversations about freedom or liberty. So it feels important to bring that around in our conversations to help folks think through what, if you walk out the idea, for example, a lot of our bathroom laws, I'm in North Carolina and from North Carolina, and we've been fighting this HB2 bathroom stuff for a long time. That is based in a fundamental Christian supremacist idea around gender essentialism, around patriarchy, and around more vulnerable people's bodies and access to safety and who deserves that safety and what that safety is about. So when we have that conversation here, we have conversations about what is that belief around the purity of white women's bodies, for example. How do we walk that all the way out and what the harm that causes is? And that gets to be part of the conversation and discussion. We don't believe in any religion without a power analysis. And that's really key to this kind of conversation. So I think I'm going to leave it right there and switch us to questions and answers because we're really hungry to hear what y'all are thinking about. And any of us can go deeper into any of the things that we've said that you heard that you're like, I want to know more. Or if there are specific questions that folks have on the call, especially for our resident legal experts, it's super just precious to have time together to be able to hold both sides of that in the same conversation.
Thank you for that, all of y'all. I want to throw one right up at the top of the stack. We had a couple of questions submitted before the call, and there's been a stack of calls or questions inside the call. One from Wes Daniels says, they're out, they had to leave, so they missed this moment, but one question they have is whether progressive folks are finding ways to use these same laws to protect people, their work, etc. For instance, is there any way religious exemptions can protect churches and groups engaging in the sanctuary movement? What about other examples? Does anybody want to take that one on our team? Catherine.
I'm just trying to, you can hear me, I'm not muted, right?
Yeah, I unmuted you.
Okay, great. We're actually working on the sanctuary issue, and I think it's a complicated question because on the one hand, we're trying to limit the reach of religious liberty rights when they're used by right-wing people to undermine racial justice, LGBT equality, reproductive justice. Yet, when religious liberty rights are being used by progressives in the context of sanctuary, maybe we're not so troubled by it. So one of the projects that Kira and I and the rest of our team here at Columbia are working on is how we can support people of faith, communities of faith that want to provide physical sanctuary to people who are at risk of deportation by using religious liberty laws, whether it's the federal law, the federal Religious Freedom Restoration Act that I referred to early on in the session, or the First Amendment, that doesn't reinforce the damage that's been done in the context of reproductive rights or LGBT rights. And I do think that there's a way that we can harmonize the use of these principles in both contexts by seeing the opportunity to raise religious liberty claims in the sanctuary context, which would look like I have a sincerely held religious belief in providing comfort, protection, and care to the most vulnerable people in our society. And that is why my religion compels me to provide sanctuary for people who are at risk of deportation and who will be sent back to very dangerous, if not deadly, situations. We can use those claims as political claims as much as legal claims. Political claims where we're able to mobilize the reasons why public policy now conflicts with what I think are widely held American values, not just religious values, but values across the country, that undocumented people or people who are vulnerable to deportation are not the kinds of criminals that the president describes them as, or terrorists or something horrible. They're people in a terrible situation, and we should welcome them. And so it is something that we're working with. You know, as a sort of ironic matter, I'm also somewhat interested in seeing about using religious liberty claims to defeat bad gun control laws. So, for instance, in Texas, you can carry a concealed weapon into any school classroom. You can carry a concealed weapon into office hours in a university context. I'm in my office right now, and I could have a student walk in if I were in Texas with a gun. That doesn't really, it's not that conducive to conversation between faculty and students, I think. I've been working with Mennonite and Quaker faculty in Texas who want to say, you know what, I have a sincerely held religious belief that there shouldn't be guns in my classrooms. I don't believe in bearing arms. So I think in some ways, if the left mobilizes religious liberty claims, it could in the longer run have the effect of muting the enthusiasm that the right wing has for using these claims to undermine advances we've had in a progressive way in the public forum.
Thank you for that, Catherine. Anybody else want to pitch in there? Let's go to another question, huh? We've got the question, how has the culture of Christian supremacy impacted the civil rights of people with disabilities?
You want me to try that one too? That's a hard one. I think it's a very difficult question. Some people tragically have a faith-based belief, I believe tragically, a faith-based belief that a disability is a sign from God of some kind of sin or condemnation by God of that person. And I think very few people hold that belief. I don't think we think that having a disability is a moral failing or a spiritual failing. But just as Kira described, there are people who have a theology of slavery or a theology of segregation. There's some people who have what they regard to be religious beliefs about disability, and that only those of us who are able-bodied are made in God's image and are therefore entitled to full civil rights. It's interesting you raised this question because this was the interview question I used for hiring people a few years ago, of how would you respond to someone who said, I have a religious belief in discriminating against disabled people because we see in my faith disability as a mark, as a critical mark from God. The way we handle those sorts of questions in the mainstream in religious liberty and disability rights is to say that you're entitled to your beliefs. Certainly you're entitled to your religious beliefs, but only up to the point where they harm third parties. So when the rights of another person are at stake, and the welfare of another person is at stake, that's where your rights end. So it's part of why we name our project the Public Rights Private Conscience Project, is that conscience is, for many people, a private relationship with God. It can govern what I do with my body, with my eating practices, my devotional practices, but I can't force other people to follow them. And I can't ask other people to bear the costs of my religious beliefs. So I think that's a little bit of where we would go. And it's an excellent question. It's in many ways a law school exam question.
That's awesome.
That was so helpful. Thank you so much.
Let's see, we've got another question that was sent in ahead of time. And somebody asks, I want to know what the likely outcome may be for the Masterpiece Cake case and which precedents SCOTUS is likely to follow, like Hobby Lobby and other cases. And y'all sort of touched on this already, y'all at the project at Columbia Law. If you want to say anything more about that, that'd be welcome.
Kira, do you want to try to answer that one? I hope your internet is stable enough back there.
Let's try it now.
Yeah.
Okay, can you read the question one more time?
The question is, or it's more of an ask, I want to know what the likely outcome may be for the Masterpiece Cake case and which precedents SCOTUS is likely to follow, like Hobby Lobby and other cases.
Yeah. So hopefully the outcome will not allow exemptions to public accommodation laws. I mean, the Hobby Lobby case kind of fell on RFRA, which Catherine discussed earlier. And the Masterpiece Cake Shop case is the First Amendment case that discusses free speech protections and religious liberty protections. So if they actually say that religious objectors can be allowed to deny services against public accommodation laws, then there's, like Catherine was saying, there's a broad range of people that they can actually, religious objectors will be able to discriminate against. And it won't only just be religious people in the LGBT community, but they could say that their free speech rights under their religion allows them to discriminate against a number of different groups. So they can say that their free speech rights allow them to discriminate against Blacks, religious minority, Muslims. So we just kind of open up the door for large-scale discrimination against any group that people think that they have a religious right to discriminate against. But it wouldn't be following the...
Kira, it's getting hard to hear you again.
I'm sorry, we're losing Kira. Oh, we've lost her entirely. She's evacuated. I mean, one interesting thing about this case is that if the Supreme Court decides that a cake baker has a First Amendment right of speech, that his argument is, when I make these cakes, it's artistic expression. I'm speaking in a way through my craft. And when I have to make a cake for a same-sex couple, I'm being asked to express endorsement of that same-sex couple's marriage. And that's forced speech that the First Amendment would not support. But if the Supreme Court buys that argument, then I think we could say hate speech laws are also out the window, right? The hate speech laws prohibit the kind of hateful things you can say, but you could have a religious reason to say hateful things. Whether it's the theology of segregation and slavery or theology of inferiority, that, the gay people are the devil or are sinful, that women who have abortions are sinful and terrible people. There are plenty of people of faith who feel that. So there's a lot at stake here. And it'll be interesting. Justice Kennedy, of course, is the only person we care about on the Supreme Court because he's the swing vote. His comments during the oral argument today kind of pointed in both directions. So we don't really know where he's going to come out, which is often the case. He's good on gay rights. He's not good on reproductive rights. He's not particularly good on racial justice. And he's Catholic. And he's a very religious guy. And a lot of his opinions read almost like sermons. So, I think this is going to be a tough call for him because he has been the principal author of all the Supreme Court's gay rights jurisprudence that have gone the way of protecting gay rights. So whether he sees this as a gay rights case or a religion case is really going to be the key, I think. Mm-hmm. Come over here, Kira. Kira's back.
Yeah.
So we are at 4:02 and we've got more time on this call for folks to ask questions. You can pull them up in the chat bar. And if not, then we might close out a little early. Ooh, a question from Taylor Parker says, do you think that the strict scrutiny given to race-based classifications versus intermediate-ish given to classifications based on sexual orientation in equal protection cases have an impact on the way that these First Amendment religious freedom discrimination cases might develop going forward?
That person, Taylor must be a lawyer. That's a lawyer question. So, what lays behind the question, gotcha, is that the Supreme Court asks a lot more in race discrimination cases in order to justify policies that have a discriminatory animus behind them or effect than they do in sex discrimination cases. And why is that? Here's a little more Law School 101. Is that we're basically committed to this idea of colorblindness in the United States. And it is a disableist term. I will recognize that given your earlier questioner. But it is a term that the Supreme Court has embraced, that when we see people, we should ignore their race, right? Just judge them based on who they are. And so anytime you're thinking about a person in terms of their race, whether it's affirmative action or what we would think of as regular discrimination, we're engaging in a constitutionally prohibited behavior. With sex discrimination, well, we're not really committed to ignoring whether a person is a man or a woman. We kind of like having a world populated by men and women. The Supreme Court hasn't quite gotten with the queer revolution that maybe not all of us are all that happy with these categories. Given that most of them are in their 80s, they're not quite there yet. So for that reason, differences between men and women are not seen as problematic when they're taken into account in distributing public goods and bads than are the differences between people on the basis of race. So there's your, the law school exam will be in a minute on that. That's sort of the difference that lay behind the question. The free speech cases are actually quite different in some ways because they're not about identity, they're about expression. And they're about ways in which I think speech is essential to democracy, that I think all of us would treasure, that we should have robust free speech rights so that we can criticize the government, most importantly. And this Supreme Court, and John Roberts in particular, have been almost, some would say, free speech absolutists that say that free speech rights should trump, and I hate to use that verb, but should overrule any other right. So you get Citizens United, where a corporation has speech rights to spend whatever money it wants in political campaigns, and other contexts where speech rights are seen as paramount to any other. So if the court decides Masterpiece Cake Shop as a speech case where the cake baker who's drawing beautiful things on a cake is seen as engaging in speech or artistic behavior that has First Amendment standing or status, then we've lost. So look for the first sentence or two when they issue their opinion in June. If they treat it as a speech case rather than a religion case, we know we're sunk. You want to add anything, Karen? Okay. So
thank y'all. Brilliance that I, as a non-lawyer, I would never have access to. And it's really cool. Thank you for that. Thank you for the question. I want to also bring up in voice, because the recording won't have the text with it, that Janice Dean in the sidebar says, just as an FYI, #CrypTheVote is a really interesting Twitter thread to follow in terms of what PWD activists are doing in terms of civil liberties, impact of public policy, etc. Would be great to see more input from the faith and justice community. I wanted to lift that up. I think that that's a really great space to continue that conversation that I'm really grateful y'all chimed in on over there at Columbia.
Right on.
Thank you.
Anybody else with questions, thoughts? Otherwise, we're going to close out and roll out.
I just want to thank you. I think Kira and I both really want to thank you all for including us in this webinar, and for the folks that are watching, thank you so much for letting us share some of our thoughts and for taking your questions. And let's do it again.
Yep. Thank you, guys. Thanks, Apple. This is great.
Yeah, thanks to y'all. We have been really excited to partner between Soulforce and Columbia Law School's Public Rights Private Conscience Project. And this has been a really wonderful space to hold with y'all. I do see somebody said they left me a comment in an email. Thank you, Paul Kinney. They say, I see a history of white religious supremacy. Yes, they came to America for religious freedom, but a great part of it was to allow them to impose their version of religious supremacy. Supremacy of all kinds have a long history in America.
Oh, we might add genocide.
That's right.
That was really part of the project as well, and at the settlement of the U.S. by colonists, settlers from Europe. So there's a lot of violence, I think, that we can find, racist and other violence in the founding of this country that's embraced by the Constitution itself at the founding. It's not a document in many ways to be proud of, and it's a document that ratifies slavery and genocide of Native people. So, yeah.
Hello, Catherine. Oh, we lost y'all.
I just wanted to say, like, on that same thread, while they're catching back, whatever you call it, dialing back in, whatever the term is, internet-wise, I just wanted to say that exact thing around the foundations of the white Christian supremacy, the genocide, the colonization, and settler colonialism of this country is specifically why we talk about spiritual reclamation and healing, because we believe in the generational violence as it impacts our people over the course of, like, the legacy of the harm that was caused on the foundations of this, what is now called the United States of America, is actually something that we have to really engage with when we're talking about fighting for our liberation, for the possibility of a world that we believe could be, is actually the process of us going back to the beginning and really sitting with what are the legacies of harm that we've inherited, and how do we interrupt and decolonize both ourselves as well as our communities in that work if we're going to be able to actually move this thing forward. And it's a lot of work to do. Some of that is in the legal side, some of that is in the political realm, and a whole lot of that is actually within our own being. So it just feels really important to always have that synchronicity of work that is both cultural change, legal change, political change, and also the decolonization and internalized violence work that we have to do for ourselves to break that cycle.
Right on.
Yeah, thank you so much for that.
Cool.
Are there any, so y'all gave your closing thoughts maybe on the, Kira, do you want to close out with any thoughts or final comments?
Thanks. No, I mean, I just want to say once again, everyone who joined us, thank you. This is an important issue. Right now, as I said, our think tank is really focused on the Catholic hospital situation. So I'll just do a quick call out because you never know who's out there. We are trying to collect stories from women who've been impacted by Catholic hospital ERDs, turned away from Catholic hospitals when they were trying to access reproductive health care. If you know if you are someone who's been impacted by a Catholic hospital experience, or you know someone, please, yes, what's the best way for them to let us know?
We're going to send out an email after the webinar is over in the next day or two, and you will have a connection directly to Kira to be able to connect about that. Oh, and once more, we lost our Columbia friends. Well, y'all should know. I will make sure that y'all connect on that. And maybe Kara will be able to tell us a little bit more about that in the email.
Never had this.
Reverend Alba, do you have any closing thoughts?
Just a big thank you for folks who stuck in there with us all the way to the end. Please look for more Soulforce online gathering space and webinars. We do all kinds of interesting decolonization and decoding and rebuilding of both our political analysis and our spirit work. And we are so grateful to our comrades at Columbia Law, and just grateful to be in community with all of y'all. So stay tuned for more.
Thank you. Yes, and my final closing out is y'all can continue to be on the hashtag on Twitter to continue the conversation. Masterpiece Cake Shop is the other hashtag that is popping off, and so if y'all want to practice some of your ethical conversation building skills today, that might be a place where you want to be. I'll be sending out emails, like I said, and we're excited to keep in conversation with y'all about this. Thank y'all for coming.
Thank y'all so much.
Bye-bye.
Bye-bye.